But imagine your family when you've gone and all they really want to do is be able to ask you, what did you want, Mum? You know, what did you want, Dad?
Even if you can just choose what flowers you want, little choices just make it that bit easier for their family members once they've died.
There is no normal, there is no should, this is your will.
People don't tend to consider who's going to inherit their personal belongings when they come in.
Should we have the right to end our lives if we want to, if we're very, very unwell? Hello. Today I'm going to be speaking with Victoria, who is a valuable member of our Wills, Probate and Trusts team. Victoria is particularly valued by us all for her wonderful way with clients and how she puts them at ease and manages to have those difficult conversations with them when they come to us for advice. Hello, Victoria. Thanks for coming to speak to me today.
Hi, Melinda. Thanks for having me.
So those difficult conversations, we don't necessarily know those conversations are going to be difficult, but so a client is booked in, maybe to make a will. Maybe they think it's going to be very simple. Quite often clients phone and say, oh, it's just a basic will. It will be really easy. And they come in, they can sometimes be a little bit more nervous than perhaps even they thought they were going to be, because they didn't expect the conversation to be quite as difficult in terms of talking about, for example, their funeral wishes. So how do you get them through that conversation, and what aspects of their funeral wishes do you talk about when you make their will with them?
I think a lot of clients are quite hesitant to talk about funeral wishes. It feels very personal, and it's not nice to contemplate your own death. And I try to make it easy and not morbid.
No.
I try to keep it light and say, even if you can just make very small decisions that you just want to be cremated or you want to be buried, or even if you can just choose what flowers you want, little choices just make it that bit easier for their family members once they've died.
And also exactly that, explaining to them that this might be difficult for you to consider now, but imagine your family when you've gone and all they really want to do is be able to ask you, what did you want, Mum? You know, what did you want, Dad? How did you want us to conduct your funeral? This is so upsetting for us. If only we had your words. And that is the type of message we try and get to clients, isn't it?
Yeah, exactly. And a lot of people don't think that it's going to be as difficult as it is, because they haven't actually gone through losing someone that close to them yet. Yeah. And they don't realise that grief can do really funny things to people and just make you not be able to make those decisions for someone.
And they don't have to put all their funeral wishes in their will, do they? They can just put the basics and then do a note or a letter alongside it.
Yeah, but I always say, if you can't make a decision now, put something in if you can, but if not, you can always write a letter of wishes, which then you can change in future or add to as you make decisions. And it saves having those really hard conversations with children, because quite often children really don't want to talk about losing their parents or what they're going to do for their parents' funerals.
Many of our clients say that, don't they? Oh, I've tried to talk to them, but they won't.
Yeah, exactly. They just refuse. Oh, why do we have to talk about that now? Don't worry about sorting that now. We'll do it later.
But it's just our experience of dealing with people making their wills, but also at the sad end of it when the probate time comes. But at least if you raise the issue when they're making their will, they go home, sit there with a bit of paper or whatever it is, and think in the quietness of their own home about the topics that you've raised with them. It's surprising, I've always found, how once people get in that zone and can go away and think about it, they really do a good job of sorting these things out.
Absolutely.
And some people can go as far as buying funeral plans, can't they? So can you explain to our listeners a little bit what funeral plans actually are?
So a funeral plan is where you pay for your funeral service, cremation or burial, and possibly your coffin, if you want to make that choice now, prior to dying. Yeah. I guess an advantage of that is that you pay for it at today's prices, and it's there. You haven't got to worry about having the money when you die either.
Yeah. I mean, it is quite a it's been a lot in the press recently about funeral plans, and so it's really important to go with a reputable provider, of course.
Absolutely.
And then it doesn't cover everything, is that there might be some extras, but a lot of people feel comforted by the fact that their family aren't going to have to find the money.
Exactly.
But the other side of it, from our perspective, is that the wishes have been drawn out, hasn't it?
Exactly.
So they don't
They've
have
made that decision.
upsetting time.
Yeah.
The other things that I've always found are quite sensitive when you come to make a will for a person or with a person is the dealing with their their specific things, maybe items of jewellery or items in the family that are considered precious.
Absolutely. People don't tend to consider who's going to inherit their personal belongings when they come in. When I ask them, they're like, oh, I didn't think about that, I don't know. Or they'll only have thought about jewellery and who gets that. But everything else, even things down to your furniture at home, people are, I don't know, I don't care, to be honest, they say.
Yeah, I think what we find is that somebody quite elderly, normally elderly women, because of course we are the ones that tend to outlive and we are the ones that tend to have more jewellery, will have quite a detailed list, either within their will or as a side letter that they consider quite carefully.
Yeah.
But as ever, it's always the unprepared situations that are worse. So somebody younger who hasn't thought about their things as such. And it's possible, isn't it, just to put one person in charge of those things.
Yes, when they haven't thought about it, quite often I'll say, well, how about giving it to your executors or one of your children, or for them to decide who gets it, if you need to sell it and put the money into the pot in the residuary estate, or donate what they feel is worthy of going to charity.
And choosing someone to share out bits and bobs or to be responsible is really the hardest decision, to find that right person, isn't it?
Absolutely, yeah.
The person that you know will be strong enough to stand up to other people trying to elbow their way in or persuade, and who's going to be fair.
Yes, it's very hard, especially when you have more than one child, or even if you don't have any children. It makes it harder somewhat if you don't, because who do you give your things to?
Well, and I think that sometimes I've been asked by clients, well, what's the normal thing? What should I do?
Yes.
And giving clients the space and the right to understand there is no normal, there is no should. This is your will. This is your asset. These are your assets. These are your choices.
Yeah.
But take into account that it's the memory you will leave. So if you're doing something that you think could be taken the wrong way, if you're leaving your very expensive diamond ring to one daughter and not the other, maybe try and let them know ahead, or at least do a letter explaining it that can be read afterwards.
Absolutely, yeah.
Because if there is only one diamond ring, there's only one diamond ring.
Exactly.
As a family heirloom. And the issue of gifts to grandchildren is something that comes up, because sometimes people might not know if they're going to have any more grandchildren.
Yes, that's quite often that comes up, actually.
And so then we talk about with clients, do you want all future grandchildren? And what about the fact that one child may have 4 grandchildren and one may have none, or one? Some
people also have children that have gotten divorced and then remarried, and then don't want some children from previous marriages to inherit grandchildren. And things like that. So it can get quite complicated and quite difficult to decide who gets what and how much.
I know.
It's hard.
I know, but having that privacy when they're in the room with you, to think or to make notes and go away and think about the things that we've pointed out to them is a hidden value, I think, of coming and making a will.
Yeah, I think they feel that they have the freedom to say those thoughts out loud that they might not have said to their children when they would. Most people tend to discuss their wills before they come in with children, and then when they come into us, they've got that freedom to discuss those difficult thoughts that they've had, such as maybe not including someone or including someone less, that they haven't been able to discuss with their children, and then they've got the opportunity to think that through and how that would affect the family, and we can advise them that actually maybe it's better to have those difficult conversations now, whilst you're still alive, so that everyone's aware of what you're doing, and it saves, or it tries to lessen any arguments after you've died, I guess.
Yeah, I think that's true. And it's not just about wills, is it? It's about the elder life, later life, that is really important. And so that's when we start to talk to people sometimes about lasting powers of attorney.
Yeah.
Perhaps when someone comes to see you to make a will, you can see a little element of confusion coming in, or they'll say, I've just been diagnosed with memory problems, and then they hadn't thought about making a power of attorney.
Yes, that quite often powers of attorney come up when we're talking about wills, and quite often it hasn't been thought about yet.
No.
But they always appreciate the fact that we've brought it up, and now they're thinking about it and realising that actually it's quite important, or more important, to put it in place than they thought.
Yeah. And I think it's really important to talk about who the attorney is and how much power that person could have. It's really difficult to think about us losing our independence to make our own decisions.
Absolutely. I think that's why people don't do it, because they're scared that they're giving away their power, and they won't be able to do anything themselves anymore. Yeah. But that's not the way it works.
No.
And they're always very relieved once they've had a proper explanation of what their attorneys can or can't do, and when they can make decisions for them.
And what the alternative is if they don't make one.
Yes, exactly. Yeah.
So just to be clear, of course, if somebody hasn't made a lasting power of attorney, it could be somebody in their 50s who hasn't made a lasting power of attorney, is very much in control of their own affairs, pays their own bills, makes all their own decisions, like we all like to do. And then something terrible happens, a sudden big viral infection, a stroke, an accident, anything that means you no longer have that mental ability to manage your own affairs. And if you haven't made a lasting power of attorney, then somebody will apply to the Court of Protection to be your deputy. And it might be the very one of your 4 children that you would have hated to be controlled by.
Yeah, exactly. I've had situations where people have come back after making powers of attorney, or even their wills, where they've appointed children as executors or attorneys, and then they've changed their minds because someone else has died or had an accident, and they've seen that actually they weren't able to manage the estate or the finances well at all, and so they've needed to change it in case anything happens to them.
And I've got many clients who have maybe more than one child or no children, and they want to make a lasting power of attorney for finances and property, which is the most commonly used one. And just to explain, of course, that means that the person can do anything to do with your finances and property whilst you've still got capacity if you want them to. Mm-hmm. So if you're just going to be abroad for a long time or incapacitated for a while, they can step in. But also the other type of lasting power of attorney is health and welfare. And I think actually sometimes and more often than we realise, people are choosing different attorneys for each of those areas of their life.
Yeah.
And I think the health and welfare power of attorney is not spoken about enough.
No.
So again, which of your children would you be the one wanting to be consulted by the doctors about your end-of-life care? And I'm meaning the very end of life, life-sustaining treatment, because there is that part within it that you can choose that.
Yes, that's right. Quite often I see that there's actually maybe 1 or 2 children that they feel would be capable of dealing with the finances, but then they want everybody involved on the health and welfare one.
Yeah.
Because they trust all of them in that regard to take into account their wishes and their beliefs and what situations they would want end-of-life care or they wouldn't.
But I think that's all well and fine if they do trust them all equally, but also very importantly if they've made it known to them what they would want.
Yeah.
And I think personally in our job, one of the most tricky conversations is to say, have you thought about whether you would want life-sustaining treatment, which is quite... Yeah. Perhaps we should explain what we mean by that.
So life-sustaining treatment includes things such as artificial nutrition and hydration, treatment for certain medical treatments such as...
Peg feeding, isn't it?
Yes.
Yeah.
heart bypass, cancer treatment, big decisions that would keep you alive, I guess, life-sustaining treatment, whether you get...
And even if you're in a persistent vegetative state, you can be sustained.
Yes.
Unless you have specified that you don't want to be.
Yes.
So it's, there was a lot of conversation about this going on as to, should we have the right to end our lives if we want to, if we're very, very unwell? And it's, at the moment, the legal position is that you can make a lasting power of attorney, and within that, appoint your attorneys to make the decision to withdraw that life-sustaining treatment if you are in a particular condition.
Yes.
And you can also do an advance directive,
yes,
which actually states, I want life-sustaining treatment to be withdrawn. I think the common phrase is DNR, do not resuscitate, but it's much more complicated, isn't it?
Yes, it is.
And it's a really awkward conversation to have with somebody.
It is. A lot of people have never thought about that. Even if they've had a particular diagnosis, they still haven't usually thought that far ahead of what will happen at the end of life. So it's a difficult decision. And again, people don't like to consider their mortality and their death. So it's good to bring it up, and they then think about it and may have made that decision.
But I've seen you in your very calm way bring it up and then pause and then bring it back in again slowly. And actually, it is an awful thing to think about, but it's really important. And if someone's got as far as thinking, I want to make a will, I want to make sure everything's all right for my kids, or haven't got kids, and therefore I don't want it to go to my long-lost cousin who lives in Australia that I haven't seen for such a long time. I'd rather it went to charity or to my lovely friends, whatever. Yeah. They've got as far as doing that. So then the next stage that you take them to is about, okay, so what about when you're not dead, but when you're really ill or really, really elderly? And once these discussions are had and the decisions have been made and documented, it's done, isn't it?
I always say that at the end. It's done now. You've made the decision. You've put the wheels in motion. It's going to be registered, and then you don't have to think about it. You don't have to worry about this. Yeah. Everything will happen as you want it to, and the worry's taken away. Yeah.
Although, of course, the next important thing is to let people know you've done it and where it is. And we've had that funny scenario. Yes. Well, we've found it funny, and unfortunately we haven't had any disasters where it's not been found. But I have had a situation where we've had inquiries, of course, from people saying, well, so-and-so's died. We found a bit of paper with your name on it, but did you actually make a will? And we say yes or no.
Yeah, quite often that happens, actually. So we do always say you need to let everybody know. At least you need to let your executors know of your will, because they need to be happy to take on that role as well. So
yes, we need to ask them before, ideally, don't you?
So then that leads into the conversation of telling them where your will is and what they need to do when you die.
And again, with the powers of attorney, asking your attorneys if they're going to want to do it, because again, it's awareness of making contact to get the original document if they need it.
Exactly.
And in terms of timing with making lasting powers of attorney, it's been well spoken about that the Office of the Public Guardian, where they are registered, are taking
the delays are huge now. They're at least 6 months to register an LPA, and that really surprises people. So it's important to do it as soon as possible whilst you've got capacity. Once it's done and it's registered, it can just sit in a drawer until if and when you lose capacity, and then it's there to be used. But if you don't put it in place and you've lost capacity before you've signed that LPA, it's too late.
So just be clear, it can't be used until it's registered.
No, it can't
so
be
there's
used.
The making of it, then the submission of it to the authority to validate it.
Yes,
and then
exactly.
Come back.
Once it's registered, that's only when it can be used.
But if someone needs one urgently, if they're going into hospital for a very serious operation from which they may not recover fully, or they're going to undergo treatment which makes them unavailable to do with they can do a general power of attorney. But it can only work while you've got mental capacity.
While you've got capacity, and I think usually for a specific decision or a specific set of decisions during that time. Yeah.
And again, going back to how long it takes to get your registered lasting power of attorney back, then when you've got the physical document back, then there is the thing of registering it with the person's bank or wherever. And so you're looking at about a year, aren't you?
Yeah. Unfortunately, most institutions aren't very quick either these days, and they all have different requirements. So that can be a bit of a job as well, registering it with the banks, etc.
So, planning ahead for when you might need help is not the easiest thing to think about. So have those difficult conversations early. Yeah. It can sometimes be more than one, can't it? Sometimes people come in for one appointment. Yeah. Food for thought, come back again.
Yeah, exactly. Think about it. Think about those things they didn't think about what we've told them.
Yeah, and feel prepared to not have all the answers the first time. I think that's another part of it. Side letters, as you've mentioned a few times, about specific wishes or distribution of specific things. They're so useful, aren't they?
Yeah, absolutely. Because they don't have to be done exactly at the time you sign your will. You can have a think about it and make that letter shortly after. Add it to your will, change it if something changes in future. You don't have those belongings anymore. You want it to go to someone else.
Yeah, or you give them away before.
Yeah, exactly. Yeah, then you can change it, update it, and pop another copy with your will.
Oh, thank you, Victoria. I certainly would feel very comforted coming to speak to you if I wasn't sure what to do with my bits and bobs. Not that I have many of them. But it's lovely speaking to you.
And you. Thanks, Melinda.